Hello, and welcome to another edition of ABI Podcast. I'm Professor Drew Dawson of the University of Miami School of Law and the Robert M. Zeman Resident Scholar for the spring of 2017. Today I'll be talking with Professor Megan McDermott of the University of Wisconsin Law School about her research on Justice Scalia's bankruptcy jurisprudence. Prior to joining the Wisconsin Law faculty, Megan litigated hundreds of intellectual property cases and appeals in private practice and as an assistant U.S. attorney in Denver and Madison, and she also founded the popular legal blog Decision of the Day. Megan has written a law review article entitled Justice Scalia's Bankruptcy Jurisprudence, The Right Judicial Philosophy for the Modern Bankruptcy Code. A link to that article is available on the ABI website, along with the link to this podcast. Megan's paper is well written and researched, and it is especially timely, given that at this moment the Senate is on the verge of filling Justice Scalia's vacant seat on the Supreme Court with 10th Circuit Judge Neil Gorsuch, a judge whose own jurisprudence has been described at times as Scalia-like. So Megan, thank you so much for joining me today.
Oh, I'm happy to be here. Thank you for having me.
There's been a lot written, as you note in your paper, a lot written about Justice Scalia's jurisprudence, about his influence on the court, but not very much on his bankruptcy work. What led you to this project?
Well, you point out something very striking, which is that there's been so much written about statutory interpretation and various approaches to it. And obviously, Justice Scalia's textualism is a real focal point for much of the academic debate. And very rarely do you see anything written about his bankruptcy decisions. And my sense is that that's really a huge omission for anybody who's studying statutory interpretation. Bankruptcy law basically it's a fertile field for a lot of statutory interpretation questions. You have this extensive code, and most importantly, you don't have any intermediate forces that are tasked with interpreting that code.
What do you mean by that, no intermediary forces?
Well, what I mean is that typically, if you have legislation that has been delegated to an agency for interpretation, you have the Chevron doctrine that says we should defer to agency interpretations of particular statutes, whereas the Bankruptcy Code doesn't have any intermediate agency that's tasked with interpreting them. So when questions come up, the courts get to deal with these statutory interpretation questions in the first instance with the full range of interpretive tools available to them. In the criminal law context, you have doctrines like a criminal statute will be void for vagueness if it doesn't give proper notice as to what is going to be punished. And can you imagine if provisions of the Bankruptcy Code could be voided for vagueness? there might not be much of a code left. So you don't have any of these forces that are going to channel the statutory interpretation questions. And as a result, it's really an opportunity to observe the Supreme Court and individual justices over time, looking at provisions of the code and trying to apply some sort of clear and reasoned philosophy for how to interpret individual provisions.
Well, and thinking about that and about Justice Scalia's bankruptcy opinions, what would you say, what are people missing out when they overlook his bankruptcy opinions?
That's a good question. I think one reason I think bankruptcy is an interesting area to study is that first of all, it's a relatively modern law. We have the Bankruptcy Code, which was completely revamped in 1978, and we have a variety of smaller amendments, and then we have the major amendments in 2005, BAPSPA. And so basically, since 1978, the Supreme Court has taken usually on average, 1 to 3 cases a year. And most of those cases involve statutory interpretation questions. So it's an opportunity to see textualism in its purest form at work and be able to make decisions about whether textualism is a philosophy that can be applied in a principled, predictable, efficient, clear manner.
Now, I wonder, too, to what extent, we can get, when we look through the bankruptcy lens, Justice Scalia's jurisprudence through a bankruptcy lens, whether you can weed out some of the obvious politics that, are often at the, lingering under the surface of all criticisms of Justice Scalia's textualism.
Absolutely. That was one of the striking features as I went and looked through all of his writings in bankruptcy law, was that there was no political predictability to his rulings. I mean, in particular, his dissents. He often was dissenting on textualism grounds, arguing that the majority's results, which often benefited large creditors over individual consumers. And he would dissent from those decisions, arguing that the majority's approach and result was just simply not consistent with the code. And so there are a number of decisions that I identified. I think in particular the Dusnip decision, Dusnip versus Tim, the 1992 decision, in which a majority of the Supreme Court held that 506D cannot be used to strip down a lien on real property to the current value of the property. And that's been one of the most maligned decisions in bankruptcy, or at least in modern bankruptcy history. In Ransom versus FIS Card Services, regarding whether a Chapter 13 debtor who owned a car but owned it outright would nonetheless be able to deduct applicable expenses that the IRS attributes to households that own one car. Again, Justice Scalia was alone in dissent, arguing that basically Congress intended to create bright-line rules, and when there are bright-line rules, we are going to have winners and we're going to have losers, and it's okay for the consumer to win under this particular application of the code. So that was really striking to me to see. You tend to have this conventional criticism that the conservative justices are there to use their tools in order to reach particular outcomes. And obviously people argue that about the liberal justices as well. And what was really a striking feature to me of Justice Scalia's jurisprudence is that did not come through in reviewing, the 25 or so bankruptcy decisions in which he either authored the lead opinion or a concurrence or a dissent. It did not come through at all, and in fact quite the opposite.
I think those are two really interesting cases, and as you point out, right, he uses a textualist lens and comes to a result that would have been pro-consumer, in favor of the individual. But both of those cases are dissents. And so part of your project, as I understand it, is that you're looking not only at Justice Scalia's jurisprudence, but also on his influence on the court and on bankruptcy law. And so it's interesting that these came in dissent. He's sort of the lone voice out there saying, nope, it's textualism all the way, regardless of if this ends up being pro-creditor or pro-debtor. So how do we measure his influence when we tend to see that sort of result in the dissenting opinion?
Right. In my paper, I describe his approach to textualism as almost Kantian. Immanuel Kant said, do justice so the heavens may fall. And I describe his approach to at least the Bankruptcy Code as, I will do justice to the statutory text, though the commercial markets may fall. And I agree that it's fair to question whether that philosophy would hold if you were writing the majority opinion. But I think there are a couple of lead opinions that he authored that we can look to see that same sense in which he's saying, look, we're going to apply the text of the code. We're going to discern the intent of Congress as expressed through other provisions of the code that seemingly are not directly applicable to our fact situation. And we're going to come to a principled outcome. And I think there are two cases I'd like to point to in particular where he wrote a majority opinion that did exactly those things. First of all, we have the Timbers case, which was actually his first bankruptcy decision that he authored in 1988. And Timbers was taken to answer the question of whether an undersecured lien holder is entitled to adequate protection payments representing the use value of the collateral if the collateral is appreciating. But along the way, the Supreme Court addressed the question of whether an undersecured creditor in bankruptcy is entitled to post-petition interest at all. And what Justice Scalia does in that decision is obviously this is a question that is not directly answered by the code, But he takes a very holistic approach, and he weaves together close to a half dozen seemingly disparate provisions of the code to try to explain what Congress's intent would have been for this precise question. And I describe this as a holistic version of textualism, where instead of looking to legislative history or looking to policy arguments about what the right result should be, instead he attempts to divine what Congress would have said by using the words that Congress did actually say in the statute. And Timbers has really gone down. You know, there were, as Judge Markell has pointed out, there were billions of dollars at stake for the commercial lending industry. And Timbers has really gone down a very important critical decision for these cases for determining what undersecured creditors are entitled to in bankruptcy. The other decision that I would point to as being very significant in terms of showing this almost Kantian textualism is the FCC versus Next Wave case. This is the 2003 case involving a bidder who had purchased FCC licenses at auction. And basically, after having put down billions of dollars or pledged to pay billions of dollars to win these FCC licenses, then filed for Chapter 11. Initially, Next Wave tried to write down the value of the licenses, but that did not fly. So then when they proposed how they were going to pay for their bid through the Chapter 11 plan, the FCC notified them that, no, in fact, we have canceled your licenses because you filed for bankruptcy. And by an 8-1 vote, the FCC had, in fact, violated the anti-discrimination provisions of 11 U.S.C. Section 525. And I think this was a very significant decision. Breyer wrote a very strenuous dissent saying that this application of 525 to these government licenses and to the government interests at stake is really going to hamper government activity in the future. But Justice Scalia was very clear that these provisions of 525 were intended to operate exactly this way, and that the government couldn't make licensing or other regulatory decisions based on the fact that a debtor had filed for bankruptcy. And I think we think of this as maybe people would be tempted to think of this as a pro-corporate decision, because obviously Next Wave won, and Next Wave is a corporation. But that said, if we look at the everyday applications of Section 525, the government plays a tremendous role in licensing all sorts of corporate and individual activity. And so consumers and businesses at all levels are going to be entitled to this protection and to the real teeth that Justice Scalia gave to Section 525. So I think those two examples illustrate that he wasn't just about applying these textualism principles in dissent. He was also doing it in majority opinions.
To an extent, Justice Scalia's jurisprudence, if it does embody a policy, it seems to embody a policy of creating predictability in debtor-creditor relations. Do you think that's a fair assessment?
Absolutely. He made that very clear in his decision in the 2012 Radlax case, where he said explicitly, hey, it's our job to give clarity and predictability to this expansive and unruly code. So he really saw it as important for the court to be applying clear principles, making clear decisions, and creating a framework in which lower courts could feel comfortable knowing how higher courts would rule on the same issues. That was his vision, at least, for the Bankruptcy Code, but whether he actually succeeded in seeing that vision come to fruition is another question entirely. The other way in which Justice Scalia tried to bring predictability and clarity is in his decisions that tried to set clear rules for the scope of a bankruptcy judge's authority and power and ability to act. And one striking example of that is his decision in the Law versus Siegel case in 2014, where he was, the question before the court was whether a bankruptcy court could tax a debtor's homestead exemption in order to pay administrative expenses that were incurred as a result of extreme debtor misconduct. Mm-hmm. So there you had a case where a trustee had spent, I think, close to $500,000 to try to track down the truth about a debtor who was claiming a fraudulent lien on his home in order to shield it from liquidation for the benefit of creditors. And the Ninth Circuit had followed its own precedent and said, yes, the debtor would normally be entitled to a homestead exemption of $75,000, but because of his extreme misconduct, we're going to take that money and give it to the trustee. And the Supreme Court unanimously said no. A court's authority to sanction a debtor using its powers under Section 105 of the Code or its inherent powers does not allow a bankruptcy court to contravene the express provisions of the Code. And because exemptions are an express provision of the Code, what the court did here in taxing the debtor's homestead exemption was improper. And this decision really cabined bankruptcy judges' equitable powers. Yet it was only 7 years after the court had seemingly opened the floodgates to those powers in the Marama case. So it was kind of an interesting turnabout. And what I find most fascinating about Law versus Siegel is it's very well reasoned, but also it was a unanimous opinion. Not a single judge said, well, wait a minute, we did something different 7 years ago, and maybe we should kind of follow that line of argument a little bit further.
What do you read into that? Do you think that it was the court itself sort of adjusting to the Bankruptcy Code, getting accustomed to the Bankruptcy Code, or is it maybe something more that could be attributed to Justice Scalia himself?
That's really hard to say. I think, comparing the situation in Marama versus the situation in Law versus Siegel, I think clearly the debtor in Law versus Siegel was much more culpable than the debtor in Marama. And I think the court in the Marama case convinced itself that the language was ambiguous and therefore it was okay to use 105 to contravene it. Whereas it's a lot harder to get around that ambiguity when it comes to exemptions. And exemptions really are at the bedrock of the bankruptcy system and the fresh start for debtors. So I think it was really taking a principle and realizing that carrying that principle too far was going to undermine the whole code itself.
Well, I want to shift a little bit and talk about Justice Scalia's bankruptcy jurisprudence and federalism. Because generally we think, a lot of these bankruptcy cases, at least the ones we've talked about so far, there's not an obvious political valence to them. And as you point out, the textualism at some point will favor, maybe corporations, sometimes individuals. But when we get to some of the federalism cases, we actually do see perhaps some tension in Justice Scalia's commitment to textualism and his concern about the overreach of federal power.
Yes, absolutely.
And Till might be a good case, I think, to consider that.
I'm sorry, which one?
Oh, Till?
Oh, Till. Okay, I was thinking of BFP versus Resolution Trust.
Let's do that. I would like to hear what you think about the BFP.
Right. Well, when you were talking about federalism, immediately BFP comes to mind, because that's a case where I have a harder time being able to argue that Justice Scalia applied clear and straightforward principles of textualism to interpreting the Bankruptcy Code. So the question in BFP was it involved a trustee's powers to avoid fraudulent transfers, typically under Section 548. Mm-hmm. And the question there precisely is, can a trustee apply 548, use his powers under 548 to undo a non-collusive state law foreclosure sale? And this is a question that had divided the circuits, and they had taken a number of different approaches to how to handle this. So you have these state foreclosure laws that allow home lenders to use state processes in order to get a judicially endorsed foreclosure sale. And often the price paid at these sales is much lower than the price that would be paid if the debtor were simply listing their home on the market, for a sale to, a consensual sale. And so the circuits had come up with a number of different rules for how to deal with these, most famously the Durrett rule, which said that we're going to assume that the price paid at these auctions is reasonably equivalent value if it's at least 70% of what we think the market value would be. And other circuits had come up with different approaches to that. And this was a sharply divided decision by the Supreme Court. It was a 5-4 decision. And the majority, in an opinion authored by Justice Scalia, held that, in fact, 548 did not apply to non-collusive sales conducted in accordance with state law. So that's a really strong federalism decision. And what it ignores, as the dissent pointed out, is that 548 itself does not include any exception for these state law foreclosure sales. And what Justice Scalia argued is that there was an ancient harmony between fraudulent transfer law and state foreclosure law, and that, in part due to federalism concerns, the Supreme Court should not disrupt that ancient harmony. And I think that that's one case where it's really hard to be able to argue that he was applying the text of the code in a very principled way. But obviously there were other concerns, particularly federalism, as you point out, that played a greater role in that particular decision.
It is an odd decision, right? It sounds almost very Justice Breyer-like in the concern for, functioning of the system, sort of the functional analysis. And I might just use that sort of as a segue into the Supreme Court's recent decision in Jevick, the structured dismissal case authored by Justice Breyer.
Yes. This was a really interesting case. You point out that Justice Breyer's opinion looks an awful lot like a Scalia decision. It looks at various provisions of the code that don't have anything directly to do with the question of a structured dismissal, but it says here, his opinion basically says, based on what Congress said about other aspects of the code, here's what I think Congress would have said about this aspect. And